I can't speak highly enough of how well qualified they are in this area. And with that, I'd like to introduce Chris Jaensch.
Thank you very much. Funny that he should mention green cards being on your table, because I will be talking about those today, but a different kind of green card. I want to start with some housekeeping issues. I'm going to tell you a little bit about myself and my firm, but also about my co-speaker, Joanne Koontz. And I'm going to start with that. Joanne has been running her own firm in Sarasota for about 4 years now. It's really one of the most dynamic and most talked about firms in Sarasota, if you ask me. It's growing rapidly. And what's interesting about her firm is that Joanne is also a CPA. So she's a lawyer who does real estate, business, sale of business, and tax issues, but also her firm can handle the accounting issues for people. So it's kind of a unique service that doesn't really exist, in my experience, elsewhere in this area. So Joanne is going to be standing by me, and she's going to be piping in, and then she's going to be taking over about halfway through this presentation to talk about her perspective, which is the tax and business law issues related to immigration when someone wants to buy a business. So please, everybody, welcome Joanne Koontz.
Thank you.
So about myself, my name is Chris Jaensch. I have a twin sister. Her name is Victoria Cairns. My sister and I both work with my father, who's also an immigration lawyer. His name is Peter Jaensch. And so together we're a Jaensch immigration law firm. We have a few other lawyers who work with us, and we just do immigration. And even within immigration, the three lawyers, we all specialize in our own little areas. And mine happens to be investor-related immigration and sports-related immigration. But today I'm just going to talk about investor-related immigration. What I wanted to do first was, some of you have seen this before, but I'd like to just give you a quick overview of how American immigration law works in general, just so you have a better understanding of how it works when somebody from another country walks into your office. So the big picture is that in this country, if you're from another country and you want to live here, we have two main categories. And often I tell people to take a piece of paper and draw a line down the center of the page, because they're that different. The left column has nothing to do with the right column. So the two ways to live here, one way is called the green card. That's also called permanent residence or an immigrant visa. Now when you have a green card, it's almost like being a citizen, except that you're not allowed to vote, and you can lose it if you do something criminal or if you move out of the country. A green card allows you to live anywhere you like, work anywhere you like, be retired, really do just about anything you want. You can come and go without really any restrictions. So the green card is an ideal thing to have, but as I'll explain later, it's very difficult to get. Now the other main way to be here are with temporary visas, and those are also called non-immigrant visas. And they're temporary because they all have an expiration date. So if you have one, you're only allowed to live in the United States for the amount of time that you're admitted, and then you must leave or extend or change to a different category. Usually green cards take anywhere from a year to 5 years to get, whereas temporary visas often will take less than 90 days to get. So I make the analogy that it's kind of like stepping stones across a river. So the first few stones are the temporary visas, and that gets you part of the way there, and then eventually you have to move on to the green card stones before you get across, and you can eventually apply for U.S. citizenship. So it's a long process often, and sometimes it can take more than 10 years. So the temporary visas, there are over 30 of them. They all begin with the letter of the alphabet. So we have A visas and B visas and C visas and so forth. And only some of them allow you to work in the United States. And even a fewer number allow you to have your own business in the United States. So the best visa really to have your own business in the United States is called the E-2 Treaty Investor Visa. Now that's the visa that you all would really be dealing with most often. So I'm going to spend a lot of time talking about that. Now a lot of times I just tell people what the big three requirements are for the E-2, because those are the most important. It's definitely something that you'll have to be mindful of. But actually today I'd like to talk to you about the 8 requirements. And some of them are very simple and some of them are a little bit more complicated. But I'd like to cover all 8 because that's going to really cover the issues that are going to come up anytime somebody walks up to you from another country and says, hey, I'd like to live in America. I think quite a few of you have probably dealt with a British family that says they want to stay, or an Italian family. Some of you deal with people from Asia, and they have totally different circumstances. For example, someone from India is going to have a completely different set of rules as opposed to someone from England. So I'm going to cover all 8 quickly, and then I'll answer some questions, and then we'll move on to the other way to live here, which is the green cards. And there is a green card for people who invest money too, and it's totally separate from the E2. All right, now, before I start, let me just tell you about the pamphlet or the material that I gave you. It's just the first of 4. You're going to walk out of here with a full handful of documents from me, and I think some from Joanne too. But this first one is just an overview of what I just told you about. So it basically talks about how there's 2 main ways to live here, the green cards and the temporary visas. It summarizes what the types of green cards are and summarizes what the temporary visas are. So that's the first one. The second one is actually explains in more detail what the 8 E2 requirements are, and that's what I'm going to tell you about right now. So to get an E2, the very first requirement is there must be a treaty, an investment treaty, between the United States and the person's home country. Now, this is the issue that comes up between an Indian and a British person, because we do not have an investment treaty with India. We also do not have an investment treaty with Brazil, with Russia, with Venezuela. A lot of places where you may be seeing people, we do not have investment treaties. We do have investment treaties with almost all of Western Europe, with some South America, for example, with Argentina, with Colombia, with some of Asia, such as Japan, Korea. We have it with Australia, Canada, of course. So we do have investment treaties with many countries, but not every country. So the very first thing you've got to find out when you're dealing with somebody from another country is, are they from a country that even has E2 visas with America? Now, to add to the complexity just a little bit, sometimes people have more than one passport, and that's something to always ask too, because there are quite a few Venezuelans, for example, that also have Italian passports or Spanish passports. A lot of times we see with South Africans where they might have an Italian passport or maybe an English passport. So it's something always to check is whether they have more than one passport, because if anyone that has a treaty with America is worthwhile to potentially get an E2 visa and meet that first requirement. Okay, second requirement. The investor has to qualify under the treaty. Now, to qualify under the treaty, generally it means they're going to be investing in America through a company, and that company has to at least be 50% owned by a citizen of the treaty country. Okay, so if you come and say to me, well, I've got somebody who wants to buy 25% of a restaurant, is that going to work? The answer is generally no. They have to have a controlling interest, which is usually 50% or more of the business in America to qualify under the treaty. Now, the third requirement is, and this is a big one for business brokers, this is the one that comes up a lot and where I get the most questions from. The investor has to have completed his or her investment or be in the process of investing. And in the process of investing, that means they've gotten so far along in the process that it's almost impossible to go back and cancel it. And so what we deal with business brokers all the time is there is a provision that says that a person can make a contract to purchase a business that's contingent on approval of the visa. Okay, so in other words, they haven't bought the business yet, they're just under contract for the business. Now, because of the rule that says you can be in the process of investing, that's permitted. So you can satisfy the in the process of investing requirement by making a contract that's contingent on the E2 visa approval or issuance. Now, what the issue that comes up with business brokers is that has to be specified in the purchase contract. And Joanne is going to talk about that. And there I have a handout that I didn't make enough copies for everybody, but I share it with you with some of the language that I like to see in purchase contracts, that contingency clause. But the contract has to contain a clause that says it's contingent on approval of visa. Not only that, but all of the money that's going to be used for the purchase has to be transferred to an attorney trust account. So that way, if the embassy approves the visa, the person cannot change their mind. The sale must be completed as they promised they would do. So sometimes the business broker says to me, you mean they can't just put their 10% down and apply for the visa? And the answer is no. They can start with 10% down, but before we submit the application to the embassy, the full purchase price has to be transferred to an attorney trust account. Okay, the third issue that comes up with this requirement is all the other contingencies have to be satisfied before we submit the application to the consulate. So, for example, a lease assignment, for example, if you're selling a business that involves leased business premises and you need to get approval of the landlord to assign the lease, that has to be sorted before we make the application to the U.S. consulate. So that's one of the things you always have to start on day one, really, to get all those contingencies satisfied, including the due diligence. because once we submit the application to the embassy expects that there's going to be nothing that prevents the deal from closing once the visa is issued. And in fact, if the visa gets issued and they come to America and the deal does not close, that presents a real big problem for the investor, because technically they're not supposed to be here with that visa. They're not using it appropriately. So you definitely want to make sure that there's really no way to get out of that contract once we submit the application to the consulate.
Will that raise a flag for them if they try to find another business?
Well, each embassy is a little bit different, but technically speaking, the regulations say that if there's a substantial change to the E2 business, you're supposed to make an application to either for a new visa or for an amendment of status with Immigration Department here in America. So technically, they're supposed to start over again, really, yeah. Now, some consulates, they grant a 5-year visa, and the person, let's say they were under contract to buy a restaurant, and then for some reason there was some undisclosed issues and it doesn't close, and then they buy another restaurant and they don't do anything. Technically they're violating it, but 5 years later they go back to the embassy to apply for the new visa, and the embassy doesn't really connect the dots to see, was this the exact same business? But I certainly wouldn't recommend it. My advice to them would be reapply, let them know that there was a change, that circumstances, something happened, and you'll get the new visa. So it's just best, I think, to comply strictly with that if possible. Okay, so we've already covered 3 of the 8 requirements, so we're almost halfway there. The next requirement is that the business in which the investor is investing must be a real and active business. So the key word is active. Now, for you all who are selling active businesses, really that doesn't ever become an issue. Just about any business that's selling a product or service is going to meet this requirement. Restaurants, daycare centers, landscaping companies, cleaning companies, just coffee shops, just about any kind of business will work to meet the active business requirement. What does not work is residential property rentals. So a person who thinks that they can buy a 4-plex and get an E2 visa is most likely not going to get one. Now, they can have that business along with something else. They can have their company own a 4-plex and a landscaping service. That's okay, because the landscaping portion satisfies the active business requirement. But just property rentals alone generally doesn't work. Also, a lot of times anything involving real estate is a little tricky. So some consulates, each consulate has the power to make their own decision and their own interpretation. So some consulates do not have a problem with development, buying a piece of land and actively developing it and building some houses or commercial property under it. Some of them don't mind that, some of them do. Some of them will allow property rentals if it's a big project, an apartment complex with 20 apartments in it, or a mobile home park that has 50 slots for rent. So if there's a higher volume, then they're more likely to think of that as being an active business. But generally, if there's involving real estate only, I would always say, involve me or involve another attorney just to make sure that you're going to satisfy that active business requirement. Okay, so we're halfway done. Now we're on to number 5. And this is an important one for business brokers too. And it's a little tricky to explain, but hopefully I will make it clear to you when I'm done. So the 5th requirement is called the substantial investment requirement. And when I say the word substantial, the focus is not on the dollar amount of money. Rather, it's the proportion of the amount invested versus the cost of the business. So really, they're looking at equity in essence. With this 5th requirement, what happens? This comes into play when there's some kind of financing involved. Now, if you're dealing with a foreign investor, chances are they're not going to get any kind of third-party financing, bank financing. They certainly won't get SBA financing. So we're talking mostly about owner financing. And so quite often I get calls from a business broker, and the broker will say, well, I've got this person who wants to buy this restaurant. They're going to put $75,000 down, and the owner is going to finance $180,000, and can they get the E2 visa? And because of this 5th requirement, the substantial investment requirement, my answer to that person would be, no, that probably will not work. So it's generally a sliding scale where the lower the total amount of the investment, the less that can be financed.